Good afternoon, and thank you for inviting me to speak on a topic which is, well, is daily bread and butter for me. But before I begin, I'd like to just begin with a caveat saying that I only represent my perspective and not of the chambers where I work, and also not of the court which I work in. I did have slides, but I shall refrain from using slides, seeing how the previous experience was with slides and the poor connectivity that can hinder the experience. With these two disclaimers, I'd like to promptly begin by speaking about um, one of the mechanisms of dispute resolution, namely arbitration. Because arbitration is emerged as a preferred mode of resolution in international commercial disputes. These disputes are between usually countries or between countries and companies. Arbitration as a mechanism is faster because it is not relying on the court procedures and protocols. It is also attributable to the judicial practices in certain jurisdictions, but can be refused for enforcement on grounds such as public policy. Now, public policy is a means through which an award or a judgment given by a tribunal can be rejected. However, as there was reference drawn to the BRICS Business Council and other mechanisms, I shall refrain from speaking about them at length, but only to refer to the WTO working mechanisms, but also the UNCITRAL model framework on arbitration, and also the New York Convention on Recognition and Enforcement of International Arbitral Awards 1958, because these have provided a framework for guiding and ratifying nations in crafting their own legislative frameworks on arbitration. The much touted party autonomy and finality of arbitral awards has thereby become a victim of public policy, given its parochial nature and the exception that it renders. But what is public policy? Well, ladies and gentlemen, it is a term which comes from the 15th century and especially from England. It was once said, and I quote, that the amorphous nature of the concept is akin to a unruly horse, and this was in 1824. However, the English justices went on to said that this enables judges to use it as a guardian angel of the integrity of the respective national systems, and that public policy is also a term where a good man in a saddle can tame the unruly horse into control. Public policy, put simply, reflects a state's fundamental legal principles and moral values that evolve over time. Arbitral legislations, like any other legislation, different from country to country. But the New York Convention is an attempt to standardize these. But these are divided into three prongs, namely the domestic public policy, which comprises of the most basic notions of morality and justice of the forum state. Second, the international public policy, which denotes a narrower part of the domestic public policy statement. And third, which is the transnational public policy, which is steeped in international law exclusively and refers to universally accepted standards and norms. Now, the paper that I have prepared for this discussion involves a discussion on all BRICS countries, but I shall speak about India and also about South Africa, seeing that there is a fellow panelist from South Africa who might be able to comment on what I have to say. But with respect to India, India happens to be one of those countries that has adopted principles of the New York Convention in its domestic law. Constitutionally speaking, the judiciary enjoys a total independence from the political branch of the state. Public policy, therefore, is not susceptible to a definition that requires an interpretation in one certain system. The courts, therefore, had to grapple with this, and from case to case have tried to come up with a definition which best explains the understanding of public policy based on the matter. However, the scope of public policy for the purpose of setting aside a foreign award usually made against a company is the fundamental public policy of Indian law. The purpose of setting aside an award can be based, as I said earlier, on justice, on morality, or patent illegality going through the matter. The extension of public policy has done an utter disregard to the precedents set in a matter involving an international company and India. The floodgates of litigation, in the sense that lose the controls of the parties, recurrent, limitless judicial review on the basis of an alleged contravention of public policy, something which could not have been dealt with in an earlier legislation that has now been amended in the Indian laws. Fortunately, these public policy reviews based on public policy rather, have been curtailed because the courts noted that domestic courts shall have no jurisdiction to pass interim orders in cases where the seat of arbitration is seated overseas, and that such will not apply to arbitrations. Legislature has intended that the courts may refuse to enforce a foreign arbitral award only satisfactory proof on the grounds of mentioned in section 48(1). Finally, the judicial approach has also focused its attentions on India to come. As I was speaking earlier, I'd now like to just I'd like to now just shift the discussion to South Africa and offer a different example, because the South African case is rather interesting. While there was also adopted principles from the New York Convention, under the arbitral awards and understanding of South African legislation, which is known as the Recognition and Enforcement of Foreign Arbitral Awards in 1977, the government had not made any declaration on reciprocity of international awards. This opens a wide amplitude that the enforcement of foreign arbitral awards is rarely capable for enforcement in the South African courts. Under this legislation, the enforcement of foreign arbitral awards is refused inter alia on the grounds of violations of public policy in South Africa. What this essentially does is that it undermines the international process and comity between courts and tribunals. This is also rejecting the arbitrary interpretation of the court and also of the legislation. The South African Constitution provides that despite waivers by the parties of their constitutional rights, courts cannot abjure fairness, which constitutes the core constitutional values. An arbitration agreement, according to the South African Constitution, contains unfair procedures and will be against the Constitution's very essence. South African courts have desisted from enlarging the scope of review of foreign awards under the lens of public policy. It, however, nonetheless goes to the credit of the South African courts that have adopted a restrictive approach to the interpretation of even Protection of Business Act. In South Africa, in 2007, the principle of party autonomy in arbitral proceedings was discussed. And in this, the court referred to arbitration agreements containing provisions contrary to public policy shall not conflict with the Constitution and therefore be null and void to the extent it contravenes with constitutional values. This was overruled in wrongful invocation of public policy by the High Court on the grounds of fraud, since the plea had already been discussed in a different suit. But what is to be noted in this regard is that the utmost freedom of contract to the parties involved, that the parties declare the contracts contrary to the sense of arbitrary and discretionary use of power, is important. Only when a transaction is shown to show harm to public interest or to basic human rights do the courts invoke the doctrine of public policy. That is one of the most important examples of the use of public policy doctrines. Of course, countries like China and to some extent even Russia don't understand international arbitral awards in their courts and challenge the very validity of these awards. India has also gone through a similar discussion, but has now finally tried to understand arbitral awards and adopt them and enforce them in the local systems. However, all being said, as was mentioned by the speakers on this panel and the panel before this, comity between courts will only stream from comity between politics and governance, and perhaps most importantly, governments. Given the nature of the political parties involved, this seems to be a viable option. So far, the prevalence of different legal standards, cultural traditions in various countries, especially those of the BRICS, have prevented such enforcement on the grounds of those such as public policy. Hence, until a harmonized approach to public policy towards foreign awards is developed at an international level, the BRICS countries may take the initiative to set up an inter-regional arbitration council to resolve intricate cases occurring in the field of application of public policy exceptions on international arbitral grounds. With those words, I finally thank the organizers for giving me the opportunity to speak and to share the stage with such esteemed panelists. Thank you once again.